Yes, sir.
Zakia Payne and Kimmy Jones need you to unmute and turn on your cameras.
Your Honor, the grandmother, Kimmy Jones, she's not a party to this case. She's just here to observe
Oh,
or watch the hearing, I guess.
okay.
The hearing began with instructions for participants to unmute and turn on their cameras. The grandmother, Kimmy Jones, was present only as an observer and not as a party to the case. The court acknowledged her presence and allowed her to remain muted. The judge noted that a temporary order had already been established in August regarding the parent-child relationship. That order addressed custody, support, and employment requirements. Child support had been calculated based on minimum wage. Mr. Jones was ordered to participate in the Choices employment program. However, he was still working for Uber and Lyft and had not secured stable employment. The state requested that the temporary order now be made final with the same term.
Okay, Ms. Jones, you can just stay on mute then if you're not a party.
We did a temporary order establishing the parent-child relationship on this case in August of this year. The temporary order addressed all the issues. It set support based on minimum wage and ordered Mr. Jones to participate in Choices. I don't believe that he's found in employment through Choices and is still working Uber and Lyft. And so we are requesting that the temporary order using minimum wage be made the final order today, along with the other terms that have already been set in the temporary order.
Okay, go and call the parties.
Okay. The state calls the father. Sir, will you state your name?
Joseph Jones,
And what are the names of the children on this case?
Zara Payne, and Zara Payne and Zakai Payne.
Okay. And we did a temporary order on your case in August, correct?
Yes, ma'am.
And you were ordered into Choices at that time, is that right?
Yes, ma'am. I chose Choices.
Did you participate in the Choices program?
Yes.
And are you still working on their program?
Yes, ma'am, I am.
Do you have any job leads or any interviews set up?
Yes, ma'am. I have a solar lead that's coming next week. So selling solar panels.
Okay, and that's an interview?
Yes, ma'am.
All right, and then since we were last here in court, you've still been doing Uber and Lyft driving?
Yes, ma'am.
Okay. Do you have any idea of what your income might be if you do get this job with solar panels?
No, ma'am. It's based off commission. So basically, I have to set the lead, and then after the lead goes through, everything will be set in stone from the sales.
Okay, and is this a job that you had Choices help you find the interview for?
No, ma'am.
Okay.
Mr. Joseph Jones was called to testify and confirmed the children's names, Zer Payne and Zakai Payne. He acknowledged the august temporary order and confirmed participation in the Choices program. He stated he was still working on obtaining a CDL license and had an upcoming solar sales interview based on commission. He continued driving for Uber and Lyft while seeking better opportunities. However, he expressed concerns about not receiving necessary documents like insurance and social security cards for the children. Despite this, he agreed to joint managing conservatorship and a standard possession schedule. He also agreed to Miss Payne carrying government health insurance for the children. He accepted the ordered amounts of $266 monthly child support, $94 medical support, and $40 retroactive support payments.
Have you been to any interviews that Choices has helped you find?
No, ma'am. Choices hasn't allowed me to get interviews. Basically, they said I signed up for the CDL license program, and I'm just waiting to hear back from them on that.
Okay, so you're to start studying to get a CDL. Is that what you're doing with Choices?
Yes, ma'am.
Okay. And are you wanting this temporary order to be made the final order today?
No, ma'am. I haven't received anything required in the temporary order, as in the kids' insurance cards or social security cards or things that was really stipulated in the order. That way I can do what was actually required of me to do in the beginning, as in the name request. And so, no, ma'am.
Okay. So are you still in agreement to be joint managing conservators with the mother
Yes, ma'am.
and to have a standard possession schedule?
Yes, ma'am.
Okay. And are you still in agreement with Ms. Payne carrying health insurance for the children through the government plan?
Yes, ma'am, that's fine.
Okay. And the order has you paying, let's see, has you paying medical support of $94 each month and child support of $266 each month. Are you still in agreement with those amounts?
Yes, ma'am, that's fine.
And the court already ordered retroactive child support and to be paid that at $40 each month. You understand that?
Yes, ma'am, that's perfect.
Okay. Is there anything else you want the court to know about your case?
Yes, ma'am. Basically, non-compliance and communication issues. That is the main thing that's going on right now. How should I say? I opened the line of communication August 8th, just letting her know that I'm open to communication with her for the better segment of these kids. And that was no reply on that one. I understand she doesn't have to reply, but at the same time, it's more of a just being open to communication with that's going on regarding of these children. Um, then another one with the payments. I don't have a problem with the payments, but the only thing that she seems to care about is the payments. I have recordings of the payment, text messages, and all communication that's going on with that. And then, how should I say, more of a, I don't want to say the lack of non-trustworthy of words. Let me say that part. So it was September 21st.
Okay. Mr. Jones, have you not been able to see the children?
No, ma'am, I've been grabbing them more than the court order required me to.
Okay. How often are you having them with you?
Every weekend.
Okay. Okay. I'll pass the witness. The state calls the mother Miss Payne.
Mr. Jones raised concerns about communication problems between himself and Miss Payne. He stated that he attempted to open communication in August for the benefit of the children, but did not receive a response. He clarified that he does not object to paying child support but feels communication is one-sided. He also stated that he has been seeing the children regularly, even more than required by the court order. According to him, he has the children nearly every weekend. After his testimony, Miss Payne was called to speak. She confirmed she agrees with child support and joint conservatorship. However, she expressed concerns about safety during visitation.
Ma'am, will you state your name?
Zakia Payne.
And Miss Payne, the temporary order that was done in August of this year, are you in agreement with that being made into a final order?
No.
Okay, and do you not agree with the child support that's been ordered?
No, it's not about the child support. I don't have a problem with the child support.
Okay, the court already set standard possession schedule and joint managing conservatorship. Are you in agreement with that continuing?
Yes.
Okay, and so you're okay with the child support remaining at $266 each month?
Yes, that's fine. I'm just concerned about the safety for the temporary weekend schedule that we had.
For Mr. Jones having the children every other weekend?
It was originally supposed to be every weekend. But since the court order, he had missed about 4 weekends. So
Okay, so what safety concerns do you
I
have?
don't know how. So for this previous weekend, Zakai Payne, half of his hand had got second-degree burn, and nobody had took him to the hospital. They just dropped him off and didn't even let me know anything. Just let me see for myself.
I object to that.
What's your legal objection? Mr. Jones, unmute yourself. You have to have
Yes,
a legal objection. You just can't say I don't agree. So, do you have a legal objection?
yes, sir. I tried to communicate that when I dropped them
What's
off.
the legal objection?
A legal objection is saying that that's not true. I've been grabbing the
Okay,
kids.
that's overruled. That's not a legal objection. Okay, go ahead, Ms. Nutt.
Okay, so Miss Payne, has there been any other instances where you had safety concerns for the children being in Mr. Jones's possession?
Prior to that, it was like scratches on their neck. I know that he has dogs, so I didn't really make a big deal of that. But when it comes to like burns, big problems like that, and accidents that I'm not getting information about or anything that's going on, I'm figuring out for myself, and then I have to deal with the consequences. I have to take off work and take him to the hospital.
Okay, so Miss Payne, how old are the children?
1 years old. They just turned one in August.
Okay, and they're twins, correct?
Yes.
Okay. Okay, I'll pass the witness.
Okay. I mean, I don't know if y'all are listening to each other today because what I'm hearing from Mr. Jones is saying Miss Payne doesn't listen to me. She doesn't communicate with me. She doesn't give me a lot of information. Miss Payne, I hear you saying,
Miss Payne explained that one of the twins suffered a second-degree burn on his hand during a recent visit and was not taken to the hospital. She stated she was not informed about the injury and discovered it herself after pickup. She also mentioned noticing scratches on the children in previous visits, but had not made a major issue of them. Her primary concern was the lack of communication regarding injuries or medical situations. The children are 1-year-old twins, which makes safety and supervision even more important. Mr. Jones attempted to object, but the court clarified that he must state a legal objection, not just disagreement. The judge overruled his objection and allowed Miss Payne to continue.
Mr. Jones doesn't give me a lot of information. He doesn't listen to me. We don't have good communication. I don't know if you haven't heard it, but that's what I'm hearing. So it takes a two-way street. You both want information. I agree you both should have it. You both should be able to communicate. I can't make you. I can't make you. But it's a two-way street. You need to ask yourself when you leave here today, am I doing everything from my side to communicate and be open? And if you can't answer that, uh, I mean, right now, I would say your answer would be no, from what I'm hearing from both of you, because the other person is not happy about the information they're receiving. So you should walk away thinking, okay, I need to do more. I need to step up my communication a lot more than that. I understand kids get hurt. It doesn't necessarily mean it's a fault of somebody or the other. It's obviously we don't want them to get hurt. But those are things that we should be able to talk with each other about. If the child has a fever, we should be able to tell the parent, hey, someone has a fever, but I gave them some Tylenol. They're doing better now. They're sleeping. Doesn't mean you have to go run and go take the child to the hospital. Doesn't mean the other parent's going to come and take the child away. Just communicate. If you have a burn or something like that, say, hey, got a burn. I'm treating it. Looks okay. I don't think you need to go to the hospital. Pretty easy. Child falls down on a bike, skins their knee. So and so fell down on their bike today. I've cleaned it up, put some medicine on it. Hurts a little bit. We're gonna move on with our day. It doesn't take a lot to send it. I mean, even today with text and email, you don't even have to have a verbal conversation. You don't have to panic on the other side either when like, oh my gosh, something happened, because these are normal things that are gonna happen. Especially with 1 year olds, they fall down all the time. If it's something that's out of the normal, then I understand. But if it's the normal stuff, I mean, just communicate with each other. I hear you both saying and complaining about the exact same thing. So it tells me that both of you are not doing a good enough job yet. So both of you need to improve on that. Um, I don't really sure about all your other complaints. I mean, we're gonna make the temporary order final order. You couldn't change the child's name until I did a final order, which is being signed today. So that's not something that you could have done anyway. But that's something that Mr. Jones you can do now after you get a copy of this order. If you don't believe Miss Payne wants to do it, you can do that. You're the father. You can also go visit the Social Security office and get an insurance card. Um, those are things that y'all have the power to do, but you should make things easier. Don't make it harder on each other. And nobody wants to sit in the Social Security office for hours when you can get the information in a minute or two. I mean, that's not the difficult there. Um, you know, um, y'all got to work on communication. That's what it comes down to. All right, the visitation that I ordered is not what you said, Miss Payne. The visitation I ordered was visitation every other weekend. Now, if
Every
y'all want to agree to something different than that, That's up to y'all. If y'all want to do more, I'm okay with that. You want to do less, I'm okay with that. That's what, if y'all want to agree to something different, that's fine. I'm
Okay.
not going to make Mr. Jones, please don't interrupt me. I'm not going to make Mr. Jones visit if he can't or doesn't want to visit. I'm not going to make him visit. The only thing that's ordered to be done is the every other weekend. Um, some people don't visit. That's just unfortunately that's the case. But I don't hear that that's Mr. Jones. So if he missed a few weekends in there, that's probably weekends he probably wasn't going to do anyway if we did it every other weekend anyway. So I don't know what the complaint about that is either there. So again, y'all need to have a conversation with each other. Maybe go drink some coffee somewhere, go have some Starbucks or something and have a conversation. A decent civil conversation about how y'all going to do this because y'all going to be together even though you're not together for a long, long time with these twins. And these twins are going to have a lot of issues throughout the time. And I know y'all may not be dating each other anymore and all that, but y'all going to have to coexist with each other as parents and communicate a lot better than you are. All right, so they'll submit me a final order. This is pretty much going to be the same as the last one we did in August, and that'll finalize your case. We won't have any more court dates. All right, y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
The judge addressed both parents firmly about their communication failures. The court observed that both parents were making the same complaint about lack of information and poor communication. The judge emphasized that communication is a two-way responsibility and both parents must improve. The court explained that minor injuries happen with young children and do not always mean negligence, but parents must inform each other. Simple text messages about fevers, small falls, or minor burns can prevent misunderstandings. The judge confirmed that the temporary order would now become the final order. Visitation will remain every other weekend as originally ordered. The court encouraged both parents to cooperate, communicate respectfully, and work together for the twins' future. The hearing concluded with the case finalized and no further court dates required.